apologies to all. Unavoidable, I'm afraid. We can sit till 4:30 if we need to.
Thank you very much. I hope that won't be necessary.
Thank you.
Now, my lords and my lady, the importance of Estoppel by convention, as I've already indicated, is that there are two substitutes.
Just, I'm sorry. I hoped that my computer issue that I noticed when I got back to my desk was not going to be a problem, but unfortunately it is, and so you're going to have to give me 2 minutes to reboot it. Sorry, nothing I can do. I see the problem. We have double authentication.
Oh, I see.
And just occasionally, double authentication likes to intervene in court hearings.
Always happens at the worst time, in my view.
Not always, actually. Just sometimes.
Well, it happened to me yesterday.
Yeah. When you were in court?
Sorry?
When you were in court?
No. No, it was last night, actually. I got over it.
Sorry, it was nearly as simple as that, but not quite.
There was an upgrade overnight.
That was it.
Right, well, I noticed I said on the transcript yesterday that we were cooking with gas. I realise that's unfashionable now, so we're now cooking with electricity.
Oh, I'm glad. Wonderful. Well, thank you, my lords and my lady. So, I hope this is not controversial, but insofar as we're concerned with an Estoppel by convention, whether by shared assumption or by acquiescence, it's perfectly possible for the relevant assumption to have been given rise to by virtue of a representation by one party to the other. And that's made clear by Lord Denning, and indeed Mr. Justice Robert Goff, as he then was in Amalgamated Property against Texas Bank.
I hardly think we need authority for that. It's obvious, isn't it?
Well, I would have thought so, and I don't think it's disputed. So the question arises...
I mean, I did, apart from swearing in duties over lunch, I had a look at Spry.
Oh, good. I looked for mine. I couldn't find it, I'm afraid.
Well, mine is a very old edition,
Yeah.
so, but it mentioned that knowledge is needed in acquiescence according to the famous case, really, of Re-Pauling's settlement, which I can't say I had time to look at. But
What year was Re-Pauling's settlement, may I ask?
64?
That was before Estoppel by convention got off the ground.
Well, it was talking about acquiescence.
Yeah, yes, which is a separate, I say separate species of Estoppel.
Absolutely.
Yeah. Oh, I'm sorry, I didn't...
Yeah, no, it's about acquiescence.
Yes,
And obviously there's always been Estoppel by acquiescence.
yes, there has.
Yeah. I mean, look, I haven't seen it, so it may be nothing, but I just tell you so you can
That's very kind.
have a look, or your junior can have a look online and see what he can find.
Well,
I'll listen to you.
And so that's actually an important point, which I'll come back to when I deal with the question of knowledge. But I'm just going to, for the moment, deal with the question of acquiescence.
Yeah.
And what I say that means is that where the assumption is communicated, is created by a representation made by one party to another, the very making of the representation demonstrates the relevant acquiescence. So in other words, the acquiescence resides in and is conveyed by the making of that representation. And I say that...
So hang on,
of course.
Slow that down. In a representation, where an acquiescence is created by a representation.
So in estoppel by representation, estoppel by in estoppel by convention case based on acquiescence, where the estoppel is said to be created by a representation by one party to the other, that representation of itself carries with it the representor's acquiescence.
Carries with it?
The representor's acquiescence. Now,
even where the representor believes accurately, or rather believes that the substance of the representation is true,
yes,
and doesn't know that the representee thinks otherwise,
yet doesn't know that, and I say it for this
and has no reason to think that.
Well, it does have a reason to think it, because by making a representation which has an objective meaning, and intending for that representation to be relied on, the natural assumption is that the person who relies upon the representation will take it at its face value.
Yeah.
And if I may say, if you can look at the, I was about to say conventional, but that's the wrong word. If you look at the typical estoppel by acquiescence cases, which rely upon silence combined with the duty to speak, it's the duty to speak arises because of their knowledge of the mistaken belief of the other party, and it's the silence which is the problem, which gives rise to the estoppel. But in a case where someone actually ventures to make a representation,
where there is a combined silence and duty to speak, there is no doubt that the misunderstanding is shared. I mean, it is shared in one sense, why one knows and doesn't speak and the other knows.
yes, but I see that. But in the case at hand, we've got a representation, which is a distinction from a...
Yes, but you've got an ambiguous representation here.
Well, I don't accept that, my lord. I mean, I say it's not an ambiguous representation.
Of course it is. I mean, when you say it's as expiring, if the expiring, if the expiring is later determined by a court to be completely different from what the expiring is thought to be, then obviously it can be misunderstood. That makes it ambiguous. I mean, it may be an unknown ambiguity, but it is an ambiguity.
Well, you have to... I'm afraid I don't...
I mean, this is the trouble with your reliance on estoppel, because estoppel is an equitable doctrine.
It is.
And equity looks to the reality, not to, if I can put it this way, common law norms. And what you're seeking to do, I would suggest, is to put a common law norms into an equitable box. And that's just not what we do.
Well, whether I'm doing
we are in a preeminently common law field here. You know, the law of insurance is riddled with rules which are rigorously applied to protect the certainty of the market.
But equity comes into play.
Well, very rarely.
Well, it does. And equitable estoppel is one area where it does.
Well, it can.
So yes, it can.
But I mean, that begs the question. It can if it applies.
Yeah, but
The problem you're saying, when you say that there's either a shared assumption or acquiescence without both sides thinking the same thing about what they're acquiescing in, it just beggars belief to me. It just makes it, I mean, stepping back from all the hundreds of authorities and rules and laws, we've all been lawyers for a jolly long time. That's not what acquiescence means. That's my problem.
well, firstly, I would say when a person acquiescence arises most commonly, such as in the Ted Baker case, when there's silence and there's a duty to speak. When you go into the realm of a positive representation being made by one person to another, and that representation has an objective meaning which is reasonably understood by the representee. Now, I understand, my lord, that you say and that because the representation could have been understood differently by different people, for example, by the representor on the one hand and the representee on the other.
But entirely reasonably.
Yes, but the meaning of the representation does not depend on what or how a representor intends it, even if acting reasonably. How it's interpreted is looking at it from the position of the representee.
Even if you were right, there cannot be injustice
Well, I think it. Well,
in holding you to your bargain.
but if that were the case, my lord, there would be no opportunity to seek relief for entirely innocent misrepresentations under the law of misrepresentation or in the law of the.
Well, innocent misrepresentations have always been treated by the law with a great deal of suspicion, actually, as we know. It took the Misrepresentation Act to
Except
change
rescission and avoidance have always been a remedy for innocent
Yes,
misrepresentation.
a rescission has always been a remedy.
But there's always so what I
That
mean
was
by
the
that.
only remedy.
At general law.
Common law.
Yeah, common law or equity, depending on your.
I just want to ask you about
Yes.
I understand your analysis.
Thank you.
You say that acquiescence is estoppel by acquiescence, properly so named, is
Yes.
a different field. And you say that the duty to speak arises because the party that has that duty realises that the other party is labouring under a misapprehension.
Yes, and in an properly so-called.
In
stop
that
by
sort
acquiescence.
of situation.
Correct.
So it's a necessary part of the duty, you say, that you need to know that there's a mistake on the other side. Follow that. If you were going to rectify a contract for unilateral mistake, I think it's fairly well established that, again, the party seeking rectification has to establish that the mistake is known to the other party and that some advantage is being taken of it. I think in the words of Lord Justice Staunton in one of the cases, conduct akin to sharp practice.
Yes. I think the authorities are mixed. There are a number of authorities which touch this issue.
Yes. But that's the general drift. General drift is, for want of other words, taking advantage of the mistake.
Right, yes.
Cynical taking advantage of the mistake. Now, what I'm struggling with is this. If the representation, which is an innocent one, carries with it some sort of notion of an agreement that the person who receives the representation should act on it in a particular way, which is really what the essence of your submission is, isn't it?
Yes.
It's the fact of making the representation, which you say has an objective single meaning.
Correct.
That when you make that representation, which has that objective single meaning, you must intend the other person to act upon it.
Yes, and those two factors combined.
Yes. That wouldn't be enough to enable you to get that contract rectified on the grounds of the unilateral mistake of the representee, would it?
Well, I think I don't necessarily agree with that, because I think certainly in relation to unilateral mistake and rectification based on unilateral mistake, yes, it's often said that the defendant needs to know about the mistake, but it's also been said that the defendant needs to, if it encourages the mistake, and that can be by way.
You can't encourage a mistake if you don't know about it.
No, but you can encourage by a mistake by making a representation, which is untrue, even though you may not know it's untrue.
I'm not sure I agree with that. You see where I'm struggling? I can't see how you can have a situation in which an estoppel by convention would create the very bargain that would be reflected in an action for rectification if you couldn't get rectification on the same facts.
Well, I don't think it necessarily follows that the law of rectification has been fashioned in a particular way, and the requirements are what they are. We can debate what they may be, but just because those elements of a rectification exist doesn't necessarily mean they bear on the elements of it.
No, but it would be a curious state of affairs, wouldn't it? As my lord says, there is an analogy between the two situations, even if they don't directly fit.
There is an analogy in the sense that the reason for the rectification is some sort of mistake in the drawing up of the contractual document or other document. And that mistake can either arise commonly or it can arise unilaterally. But obviously, estoppel by convention or a deemed estoppel by representation can extend beyond that.
So the acquiescence for which you're contending is some kind of intention, not a subjective intention, that the other party should understand the contract and or understand the representation and act upon it in the way in which objectively it turns out it is to be understood, even though that wasn't the subjective intention of the representor when he makes it.
Correct, and I say it for this reason, my lady. Whether you're talking about misrepresentation of common law or the equitable remedies or whatever you may wish to say about it, the reason why the misrepresentation doesn't have to be fraudulent for it to be actionable or to attract a remedy of any sort is that the person who makes the representation takes responsibility for the truth of it, even though they may be it may be entirely understandable why the representation has been made. But in this particular case, if I may say so, what has happened is the representation as to the terms of the policy by reference to the expiring policy. And I understand the subjective understanding of Edge by reference to what they understood the expiring policy to mean. But the fact is, there was no communication to the following underwriters, by Edge or by anyone else, or discussion with the following underwriters of the terms of the endorsement or its content.
Well, they sent, they sent them a copy of the slip. I mean, in the case of Ark, they had the slip.
Well, they had the slip, but they were deterred from reading it because of the representation.
They weren't deterred from reading it. They were told it was as expired. They were given a slip, and then they discussed all the changes.
Yes, and if you're content with that, there's no need to look at the policy. If you're relying upon the representation.
Well, you may think there's no need to, but you fail to read it at your own risk. That's the point.
You could say that about, my lady, you can say that about any misrepresentation, about anything.
Yeah, but you see, in a normal case of misrepresentation inducing a contract, you'd say, well, it's not an answer to a misrepresentation case that you actually signed the contract. In fact, that proves the inducement.
Yes.
But in most cases, you'll be pretty rapidly held to have affirmed it if you don't do something to set it aside fairly swiftly.
Yes, yeah. I mean,
so,
in relation, yes. Okay. I mean, I've been over affirmation. I don't tend to. I'm happy to go over it again.
No. I mean,
yeah.
the point that I'm trying to make is that misrepresentation cases depend very much on the facts and circumstances.
They do.
But here, there's never any. If there's a subjective intention to mislead somebody, then the answer's easy. If there's no subjective intention but the parties are at cross purposes, I'm still struggling to see why it is that as a matter of equity, when it's open to the party concerned to find out the truth by reading the document, it is the representor who's acted entirely innocently who should suffer, or his client who should suffer, rather than the representee who doesn't read the document.
Well, as I said before, if you look at the commentary in relation to Cartwright, any negligence on the part of the representee in relying upon the representation is an irrelevance. And that's a well-established proposition, whether it's in terms of estoppel or in terms of, now I think when he's referring to estoppel there, he's referring to estoppel by representation, or when it's referring to more substantive relief from misrepresentation. And it's never been the law, at least in relation in equity, and it's obviously changed, and certainly in relation to contracts with the utmost good faith, that a misrepresentation is actionable only if it's fraudulent. And the difficulty I have, my lady, if I can say this, is with the suggestion that there must, in the case of a representation, be knowledge on the part of the representor that the representee is labouring under a mistake, is that essentially you're confining the estoppel by convention in that particular case to cases of fraud. Because you're saying that the representor must be aware that the representee is acting on a particular state of affairs.
Well, not necessarily. It doesn't necessarily have to be fraud. There could be a case where both parties genuinely believe that their interpretation of the contract is right. Turns out one of them's right, the other one's wrong.
Well, no, I think you're right. I accept that. But what I don't understand is in circumstances where, in relation to all other areas of law, making a misrepresentation is actionable, even in the case of an innocent misrepresentation. The reason for that is that once you make a representation, the representor takes responsibility for it. In circumstances, it has an objective meaning and it's intended to be relied upon. And this also satisfies the other requirement in relation to estoppel by convention, that there must be this crossing of the line. It's the communication which matters. And the representation is, if you like, the archetype of a communication for this purpose.
Communication of what, though? Because as I read it, it's a communication of mistake.
Well, that's the whole point. It's a mistaken assumption. It's a representation that the policy is on the same terms as the expiring policy, which is untrue. That's exactly right, my lady.
Crossing of the line, the whole concept, originates from rectification, where what you're talking about is a continuing common intention, and what has to cross the line is a statement of one party's understanding that has to go across to the other party. So there is never any question, because the two sides are subjectively assessed. What is being assessed is a communication of a subjectively assessed common intention. Here you're trying to persuade us that there can be crossing of the line as some sort of common law requirement, even if there is no, the two parties are completely misunderstanding what has crossed the line. And that's obviously runs into the problem of the fact that it's an equitable doctrine. It's not, I mean, if they were fraudulent, it would be one thing, but they're not. What happened here was a genuine misunderstanding. Both sides were, as my lady has pointed out, at fault in different ways, with different misunderstandings. Neither party can be blamed for not knowing what the terms of the existing was, because it had to be determined after a 5-week trial. And so it's most unfortunate. It's just not the stuff of Estoppel. I mean, the judge got it all right. And anyway, you've got the NAC, which you'll come to.
Well, I'll come to that. I may deal with that separately.
Yeah.
That's
the problem that I think you're getting out of me and my lady. That it's it may be intellectually, one may be able to see it intellectually, that it's a possible argument, but it falls foul of the smell test. Just doesn't work. And sometimes cases are like that.
They are. I mean, the elements of an Estoppel convention are laid down. And the real debate we have today, if I may say so, is the question whether, when you have an Estoppel by convention based on acquiescence, in most cases that will probably relate to circumstances where one person says nothing and the others are labouring under a mistake. And the only connection you can draw then between the two persons is the defendant's knowledge of the claimant's mistaken assumption. In a case of a representation, the position is different. Because there...
And it would be if it were a representation that the sun rose at 11:15. You know, but
which is obviously wrong.
Which is either obviously wrong, or clearly right or wrong. But here you have something that is ambiguous and needs resolution and is difficult, and therefore it's not a representation of clear understanding. I mean, the example that I gave is it was too clever by half, because what I really meant was the sun rose at 8 a.m.
Which is more...
Which is either right or wrong.
Depending on the time of year.
Depending on the time of year, whatever. But you get my point.
I do.
It's not ambiguous.
Well, so here, forgive me for saying this. I mean, I say it because that's my submission. Is that it is unambiguous. I'm not
no, you say it's unambiguous because you have to take an objective view of what that means.
By reference to the position of the representee.
Reference to the position of the representor.
No, representee. The person who receives the representation.
Right.
So the reason it's unambiguous is because you don't judge it by the position of the representor, but by reference to the position of the representee. Right. The meaning of a representation, objectively, depends on how a reasonable representee would understand the representation. And in this particular case, the representation is that...
And is there authority for that proposition?
I'm sure there is. I'll ask my junior to look for it a bit. I'm sure the cases are replete. If I may, I'll come back to that. But just assuming I'm right on that in that submission, so that you indulge me to that extent.
Yes, well, I mean, I can see it's possible.
In this particular case, what had happened was the representation that the policy was in the same terms as the expiring policy. Now, of course, there's an explanation as to why Edge thought otherwise, in the sense that they thought it included the TPC when it didn't. But the judge found there was a misrepresentation. And the reason why Edge's understanding, or if you like, the explanation for their understanding, is not relevant to this purpose, because there's no evidence whatsoever, and indeed the judge found to the contrary, that the endorsement of the previous year was not communicated or discussed with the following market. It was not something they were aware of.
Well, I think it was a misrepresentation because, as a matter of fact, he had found they were not bound by it.
Correct. But it's nonetheless a misrepresentation. Whatever the reason, it's still a misrepresentation.
Yes.
And therefore, you ask yourself, is it unambiguous, having regard to the position of Ark and Advent as representees? And I
you see, if you're right,
yes.
Let's assume you're right,
yes.
and that there's authority that it's how the reasonable representee would understand it, and in the law of representation, this is a misrepresentation, right? It's false. Because irrespective of ambiguity, that's all a bit of a red herring.
Right.
It's a misrepresentation, therefore it crossed the line, it was false.
Yes.
And the representor is responsible for it rather than the representee.
Yes.
And then we come to injustice.
And I'll come to that, yes.
Yeah. So you may prove too much because you may say, okay, if you apply rigorously the law of misrepresentation to the concept of estoppel by convention, which is, by the way, the reason why I think this categorization of estoppels in the way you do it, saying you've got to comply with this, 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 and this, and if you don't, it's useful for judges sitting in first instance, but it can give rise to problems because every case is different, and an estoppel is only allowed to run if there would otherwise be an injustice.
Correct.
I mean, if you read High Trees or something like that, you see that riddled through the jurisprudence. Unfortunately, we've now thrown away the sort of the ribbon of injustice and allowed ourselves to go into this categorization which the Supreme Court loves and does in every case. So we have a list of factors that we have to tick boxes for, and if not, the case doesn't run. And then suddenly we find there's another case which is a hard case and doesn't fit within the factors. So we go back to the Supreme Court and they change the factors, see bench dollar and the additional crossing of the line and so on. I mean, all this does illustrate, I mean, I'm not saying this is not a very interesting case, Mr. Eggers, but what it illustrates is that we are a court of justice and we have to only do things when they're right.
According to law.
And they're legal, right, and legal. And the problem with a doctrine of estoppel, which is an equitable doctrine, which creates injustice and destroys the certainty of the insurance market, to me, raises a red flag.
Well, I don't accept, my lord, that a representation of this nature, which is a commonly understood...
Made all day long in Lloyd's.
It is.
Yes.
It doesn't mean it doesn't lack significance, and it doesn't mean it's not relied upon. It happens.
Nobody suggested it wasn't. No.
No.
It is relied.
Yeah, but it shouldn't.
But the person who relies upon it knows jolly well that if they don't read the slip, it's their problem.
Only, well, not if they take the representation on faith and they acting, and if they, I mean, you don't even have to act reasonably reliant upon it.
You have thousands of cases where they say, I didn't read the slip, which, brackets, they never do, and I didn't because he told me it was as expiry, and it wasn't.
The evidence from the judge is clear. The evidence from the judge is, the findings of the judge are clear. The judge indicated there was reliance by these two underwriters on this representation, and they signed the slip as a result of that representation.
Absolutely.
And in those and I say, as my lord accepts, notes, I should say, that this is a representation which is commonly made, and I would go further, it's commonly understood to mean one thing, which is the policy which is being placed is in the same terms as the policy.
But they knew that wasn't true. I mean, because he then went on to say how it wasn't as expiry.
Well, it was
a generic term. It's generally as expiry.
With certain exceptions.
Subject to some things.
Which were discussed.
Some things were discussed.
Some were discussed with one of the underwriters and some were discussed with the other.
Yeah, but doesn't mean...
the same.
But they were different things because, the premium changes.
Therefore, the representations to each of the underwriters must be judged separately because they're separate representations as the judge judged them. But the judge indicated the material changes were discussed.
And particularly when you say terms as expiry. Anyway, look, I mean, we're probably getting bound up in a very interesting philosophical debate.
Yes.
You carry on with yours.
I'm sorry. I'm sorry. I didn't mean to.
It's not your fault. It's ours, and it is an interesting philosophical debate. So we should.
But anyway, so I think I made my submission clear.
I think you have, and if I may say so, they're a lot clearer than we understood them before, and that's because you didn't even have a single skeleton argument. So your skeleton arguments are a bit diffuse. But what you've submitted to us, and I've noted down, and my lady has fed them back to you, so she understands too, is very clear.
Thank you very much. That's very kind, mate. Just, if I could just make, so I think the next point I wanted to make is concerns, just going back to Liddon and Jones, as we looked at before, which, and that will help me introduce the question of knowledge, which I'm just going to make few more points about that. So Liddon and Jones is at tab 16. And I think, I don't know if my learned friends checked, but I've only found 3 cases since Tinkler which comment on Tinkler. But of the 3 I've seen, this is the only one which I think is relevant.
I don't think Liddon and Jones is tab 15.
16.
16. Oh, yes, it is.
Yes.
Thank you.
Which part of Leiden and Jones do you want us to look
Leiden.
at?
Well, sorry, my lady. I was going to take you to paragraph 54, which is page 569.
Five, 6, 9. On the PDF, or?
Sorry, 569. I beg
The
your pardon.
internal
I think it's
pagination.
the same, actually.
Oh,
What does it say?
thank you very much.
53, 4.
54. There is in paragraph 54, we have reference to Lord Borough's judgment of paragraph 45. I stress, of course, that Lord Borough's was looking at a shared assumption case, not an acquiescence case.
Yep, got that.
And at paragraph 55 on the next page, I don't think I need to read, I mean, you've seen that judgment, that part of the judgment before. Paragraph 55, Sir Anthony Mann says that although that dictum refers to non-contractual dealings, the authorities make it plain that the same principle applies to contractual dealings. There is also a gloss or elaboration on the first of those principles in that it's been made clear that the first principle should be amended to include the crossing of the line between the parties may consist either of words or conduct from which the necessary sharing can properly be inferred. That is a reference to the feature that the assumption must be expressly shared between the parties. It is necessary to clarify one additional matter in relation to doctrine. The common assumption need not be a shared assumption if it is held by one party and the other has acquiesced in the first assumption. This is apparent from the formulation in Republic of India, which I've taken my lords and my lady to. So what I say that makes good the point I made before, that here, for the purposes of an acquiescence estoppel by convention, you don't have to have this sharing of an assumption. They don't have to both have the same assumption. Now, whilst I'm in this judgment, my learned friend took the court to paragraph 58, where Sir Anthony Mann referred to that in the acquiescence in the assumption of another, it's necessary for the first person to know the assumption of the other. So here, it's making the point which my learned friend makes, which is that you can't have an acquiescence underlying an estoppel by convention without, in this case, Edge knowing of the mistaken belief of the underwriters. Now, what I say about that, my lord, is firstly, it was common ground. So it was a concession by one party, and that's what led the judge to it. So Sir Anthony Mann therefore found it unnecessary to comment on the authorities. So we don't know what authorities he might have had in mind. What's interesting, however, is this. In paragraph 61, he goes on to refer to the fact that Mr. Cunningham, who made the concession, I think, also invoked every other form of estoppel, including estoppel by representation, which is then outlined in the requirements on the page. And what I wanted to then move was paragraph 66 at page 572. So here, what Sir Anthony Mann says is there are some principles which can be extracted from the above authorities which are particularly significant in this litigation. The essence of an estoppel is that a party is forced to accept a legal factual position which is not necessarily the actual position. It gives effect to the erroneous belief of the person with the benefit of the estoppel because the other person has either given rise to it, usually by a representation, or has shared it, open brackets, estoppel by convention where there's a shared assumption, or has himself or herself gone along with that belief without actually sharing it, estoppel by convention where one side acquiesces in the erroneous belief of the other. estoppel by convention based on acquiescence fills a gap where a person is responsible for the belief of another without actually creating it in the first place by representation. So I understood it was common ground that an estoppel by convention could arise by a representation, but what Sir Anthony Mann was doing here is excluding the possibility that an estoppel by convention by acquiescence, or indeed estoppel by convention at all, can arise by virtue of a representation.
Well, only estoppel by convention based on acquiescence, in fairness to him. Because that's what he says. He says it fills a gap with
yes, you're quite right. You're right. But, and of course, that's what we're concerned with. So when Sir Anthony Mann is considering acquiescence underlying a estoppel by convention case, and he indicates that knowledge is a requirement, firstly, he does so based on a concession without identification of the authorities, but more importantly, he does so in the belief that such an estoppel doesn't arise where a representation is the cause of the mistaken belief.
Well, like everything, you know, the cases dicta are governed by the case before them. So to extract out of that sentence a sort of general proposition that there can never be.
I'm not saying it can't be. I'm saying he's wrong to say that.
No.
Yeah.
Exactly. But I mean, to even construe that as being a general statement of the law, all he's saying is, in the circumstances of this case, this gap is filled in this way. But
Correct.
I mean, he's not really saying, I don't think. I've thought about this and looked at all the authorities.
But the point I think I'm making very clumsily is that insofar as we're concerned with an estoppel by convention acquiescence case, based on a representation, nothing that Sir Anthony Mann says about the requirement of knowledge assists, because he's concerned with the scenario, to use his phrase, where the belief of another is not created in the first place by a representation. So he's in identifying this requirement of knowledge, he's not including in that assessment a representation case.
I think he's doing that because in context, as my lord says, when you're actually looking at the case that he's dealing with, there was an argument about estoppel by representation, and he'd probably taken the fairly understandable and simplistic view that if you can't get home on an estoppel by representation, you wouldn't be able to get home by an estoppel on convention based on the same facts. But in any event, the point you're making is that his remarks do not cover a situation where somebody is trying to argue an estoppel by convention based on acquiescence where there is a representation.
Which is this case.
Anyway, I see what you're saying,
yeah.
and you know, personally, maybe, you know, I think one always looks at first instance decisions with a little care, because they are always dealing with their facts.
Of course, but I'm afraid that's all I've got to go by as well, and so I can only do what the judgment says. I can only make submissions based on that basis. Now, the other authority, of course, when it comes to knowledge, which is so I rely on this case. I rely on this case to demonstrate that there doesn't need to be a cross purposes sharing an assumption in a case where it's an acquiescence case. Because that's what Sir Anthony Mann says in paragraph 56. But I also say that insofar as he's laying down a requirement in relation to knowledge, it's not applicable to the case at hand or this court.
No, but you say the other authority is Mr. Justice Blair's authority.
Yes, so apart from, there's Mr. Justice Blair, but before I should also say that when it comes to my learned friend's supplementary skeleton, there is a comment, and I don't know if you want to have a look at it, it's the supplementary skeleton bundle. So you should have a separate bundle of supplementary skeletons.
Yes.
And I think it's page 36.
which paragraph?
Well, so it actually begins at 35, which is paragraph 10, where there's a reference to a decision, having referred to Jones and Leiden, there's a reference to a decision Mr. Justice Calver in Active Media Services. And it goes on to the next page, but you can see at the top of the page there's a footnote number 7.
There's a footnote. Which number?
7.
7.
Which refers to the authorities referring to estoppel by acquiescence. But this is shorthand for estoppel by convention through acquiescence. Now, I submit that's wrong.
I think that's not right. I mean,
So that I submit that's wrong. But
A, it's wrong, and B, it ignores history. Yeah. Anyway.
But the other point is you'll see in footnote 10 on the same page, and also a number of authorities referred to. Now, I've gone through each of these authorities. They're not all in the bundles, and we waste the court's time to look at them, but I've been through them all, and they either deal with acquiescence alone or they deal with acquiescence separately from estoppel by convention. There's not a converging of the two doctrines. So the two cases where there seems to be this requirement of knowledge in relation to an estoppel by convention case is Jones and Leiden, which we've just looked at, and then Starbev, which is Mr. Justice Blair's decision. Now, in Starbev, it's a bundle, sorry, it's the authorities bundle, bundle 10. Sorry, just one moment while I get my reference. Now, again, this is not meant to be a criticism of Mr. Justice Blair's judgment, but I suspect there's an error in his thinking, which I just want to draw your attention to, which is paragraph, so page 367, page 123.
It's not a criticism to say there's an error in his thinking. Yeah.
And at 123, we have what can only be described as ubiquitous quotation of Lord Staines' judgment in Republic of India. And what's interesting
So which paragraph are you at?
123, my lord.
Oh, I'm sorry.
Page 367.
Yeah. I mean, do both parties here agree that the authoritative modern statement of the principles applicable are to be found in Lord Staines' judgment?
Correct. The reason I suspect what's very interesting from Mr. Justice Blair's judgment, he quotes Lord Staines, and you can see on the next page, 368, having gone, the first paragraph relates to estoppel by convention, then Mr. Justice Blair refers to the quote, estoppel by acquiescence. And I think, as when I took my lords and my lady to Lord Staines' judgment, Lord Staines clearly dealing with two separate doctrines. Estoppel by convention first, acquiescence second. I think Mr. Justice Blair's conflated them and applied an acquiescence approach, which requires knowledge in the case of estoppel by convention. But what's interesting here is, this is not in any event, this is not a case involving a representation or misrepresentation. And what Mr. Justice Blair says at 127 on page 369, what he's really concerned with is an acquiescence case where there's duty to speak, and he says, in the present case, where there is no such relationship between the parties, for the purposes of estoppel by acquiescence, it's common ground that silence on the part of a party to a contract can only amount to acquiescence where there is a duty to speak. Mere silence, inactivity, or failure to take a point cannot be enough to found an estoppel by convention. So that's the, if you like, the classic statement of an acquiescence. And of course, in this case, I say, that there is, this is not a case of silence. This is a case of a positive representation. And if I need to go further, I would say, given that it's a contract of the utmost good faith, once a misrepresentation is made, there is a duty to correct it before the contract is concluded. And if it's and that's why you get so-called continuing representation. So if a representation is made 6 months before the contract, it will continue in force unless and until it's corrected. And if it's relied upon, even though it may be relied upon 6 months after it's made, it still has effect. So with that introduction, I'll say knowledge is not a requirement, at least where there's a representation, because we're not in the realm of a duty to speak, we're in the realm of a positive representation having been made. And that representation itself gave rise to an assumption made by Ark and Advent. And because it was made objectively with the intention that it be relied upon, that is sufficient to establish the estoppel by convention. Now, my lords and my lady, I'm going to move on to the NAC, unless there's anything else I can help you with on this first round of appeal.
No, thank you.
I think I've made my submissions on why I say, at least, the representation was unambiguous rather than ambiguous. And if you want me to repeat it, I can.
Yes, you don't need to.
I beg your pardon, my lord?
You don't need to.
Very good. Before I move on, just 2 housekeeping matters, if I may. One is there is authority for the judging the truth of or the meaning of the representation by reference to the position of the reasonable representee. I can provide it by email, a copy to my learned friend after today. Would that be more? I think it could be.
What's the best case?
The revising central bank case. I think it was a decision of Mr. Justice Christopher Clark, but there was also there are earlier cases such as Goldman Sachs against IFA. Yes. In Re Paulings, my lord, I think you asked, that involves acquiescence in a breach of trust.
Yes.
And whilst I read those words out, I know more about the case than that, because it's my learned junior who's done the research. And then finally, my lord, you asked about who the acquirer and owner of property in the Moorgate quote.
Yes.
So there, what had happened was, and my lady was absolutely correct, this was a case where a car dealer was acquiring a car, and it was a hire purchase arrangement with a hire purchase company. So the hire purchase company was the owner of the car because it advanced funding, and the hire purchase, there was a pre-existing hire purchase agreement on the car. The hire purchase company was the owner of the car. The car dealer who wanted to acquire the car consulted a register as to whether or not the hire purchase agreement was registered, any earlier hire purchase agreement was registered. It was all clear. And then the car dealer acquired the car. And so the hire purchase company saying, well, actually, that's our car. So sued the car dealer in conversion for damages. And the car dealer sought to create what was called an estoppel by negligence. So another estoppel. This is obviously before the days of estoppel by convention. And on the basis the hire purchase company should have taken steps to have its hire purchase agreement registered. So the short answer to my lord's question is the acquirer is the car dealer and the owner was a hire purchase company.
Thank you.
My lord, I come on to the NAC, and it's probably best if you have the copy of the NAC before you, which is in bundle, the core bundle, tab number 10. Now, my first point is that if you just look at the language of the clause, it's not there. It doesn't exclude the opportunity for any party, whether underwriter or insured, but particularly underwriter, of course, to rely upon an estoppel, even one created by a representation. And I say that for these reasons. Firstly, this is a clause which you see more commonly in the non-marine market. You do see occasionally in certain types of policy in the marine market. So the idea, of course, is it limits the opportunity of the underwriter to, for example, avoid the policy based on a non-disclosure or misrepresentation, or exercise another remedy based on a non-disclosure or misrepresentation, unless it's fraudulent. Now, what this clause is getting at is the duty of the utmost good faith. This is referring to a non-disclosure or misrepresentation made by the insured or on behalf of the insured in breach of the duty of the utmost good faith. And that's how I say this clause ought to be understood.
So just say that again. It's getting at a non-disclosure or misrepresentation made on behalf of the insurers.
On the insured, behalf of the insured.
On behalf of the insured, yes.
In breach of the duty of the utmost good faith. Now, that means that what this is really concerned with is a scenario where there is a breach of duty and that gives rise to substantive relief. And that may, and of course, at this time, the Insurance Act had not yet come into force. So it was under the old Marine Insurance Act provisions of Section 18 and Section 20, which essentially limited the remedy to a right of avoidance. But that doesn't mean there weren't other remedies available. So, for example, there was always a right to claim damages under the Misrepresentation Act of 1967. And that right still exists as a matter of law. And in rare circumstances, you can also have it in the context of negligence. And where the representation itself, or the non-disclosure, if relevant, is itself built in as a term of the contract. So, for example, there may be what's called a basis clause, by which the representation is warranted to be true by way of a contractual warranty. They're now abolished by the Insurance Act. You can't do that any longer, but in those days it was still possible.
You say simply it's the wrong way around. It's looking at an insured's representation, not an insurer's representation.
Yeah, but what I'm saying is it's looking at the representations and non-disclosures made in breach of this duty owed to the insurer.
Yeah, but I mean, it's just the wrong way around. You say that this is a rejection of liability based upon an estoppel which arises from by sheer chance, completely fortuitous,
yes,
but from a representation made by the underwriter.
But by the broker.
By the broker. Oh, I see. Yes. No, I've got it wrong. No, sorry, I'm getting it confused. Sorry. No.
No, you can. I was.
So no, I don't really see why this doesn't fall within the clause.
Well, the first reason is it doesn't refer to estoppel at all.
I get that.
Yep. And
does it need to?
Well, it does for this reason, if I may, my lord. Mm-hmm. So, for example, there are two cases I'd just like to take your lordship to. One is in the Authorities Bundle, tab 6. Oh, sorry, I'm looking at the wrong button. Tab 6. Now, this is HIH against Chase, page 160.
Yeah.
And this was a case where it was an insurance policy, it was a film finance insurance policy. And there was a provision in the policy, which is, I mean, it's too long to read out. You can see it in the head note at the bottom of the first column and the top of the next. But the essence of the...
Just what's the point we get out of this case?
When a party has a right or a remedy available to it as a matter of law, if it's going to be excluded or waived under a contract, the clearest language has to be used for that purpose.
Well, I would have thought that was obvious.
Yes. So in this particular case, and I want to take two cases because I think they're quite striking, if I may say so.
Yeah.
In this particular case, there was the clause that you can see in the head note, which basically excluded either the duty or the liability for breach of duty on the part of the insured to disclose information unless it's fraudulent, or a misrepresentation unless it's fraudulent. Now, the House of Lords construed that provision as saying because there were at that time, it's no longer the case, but at that time, there was an independent duty of disclosure upon the insurance broker, who's the agent of the insured, and that wasn't separately excluded. That there was no such exclusion of that duty. Now, one would have thought, as a matter of ordinary interpretation, the exclusion of a duty of disclosure on part of the insured would extend to any duty of disclosure on its agents, including the broker. But that's not the House of Lords construed it. And you can see the reasoning at paragraph 11 on page 166. And one of the questions arose as to whether or not the clause was effective to exclude negligent misrepresentations and negligent misrepresentations, giving Canada's steamship as a line of authority. And what Lord Bingham said, that there can be no doubt, I was taking about 6 lines down from the beginning of paragraph 11.
There can be no doubting.
There can be no doubting the general authority of these principles, which have been applied in many cases, and the approach indicated is sound. The courts should not ordinarily infer that a contracting party has given up rights which the law confers upon him to an extent greater than the contract terms indicate he has chosen to do. And if the contract terms can take a legal and practical effect without denying him the rights he would ordinarily enjoy, if the other party is negligent, they will be read as not denying him those rights unless they are so expressed to make clear.
I mean, we don't need this authority for that. I mean, it's so obvious because, you know, exclusion clauses have to be construed strictly.
Correct. And is the NAC's exclusion clause?
It is.
It is.
Yeah.
Yeah.
Of a kind.
No, well, it is.
Yeah.
And the other case, I don't need to take you to, I'll just explain briefly what it says. It's the Cape Barry, which is actually in the TPC authorities. I don't know if you want me to take you to it, but I'm happy to. Well, let me explain what it is.
Just tell us what it is.
Yes, it was a case involving a contract between a ship and a oil facility, where the ship would come and load from the facility. And there was a provision in the contract by which the ship owner agreed to indemnify the facility against all damages. The issue arose here that, as a matter of law, a ship owner is entitled to limit its liability by reference to the tonnage of the ship. And the question arose whether a promise to indemnify all damages meant irrespective of the limitation right, or was it read subject to it? Now, there's no reference to the limitation convention or the Limitation Act whatsoever in the contract, but the Privy Council nonetheless held that if that was the intention, reference should have been made to it. And it wasn't. So the Privy Council held in the end that even though there was a promise to indemnify against all damages, that wasn't sufficient to exclude the right to limit. So here, I say, my lord, looking at the NAC, that what the clause is clearly getting at is the breach of a substantive duty which gives rise to relief by way of misrepresentation or non-disclosure. But that won't extend to any estoppel, because that's a principle of justice which applies independently. And if the intention had been for the NAC to exclude that right, it ought to have expressed reference to the estoppel directly.
Right.
We have a separate argument, which is, of course, that the representation which gives rise to the estoppel embraces not just the TPC but the NAC, because it's in the same position of the NAC. Now, I quite recognise, however, the judge, even though that was the argument before the judge, both by Mr. Parsons QC on behalf of the underwriters, and also it's recorded in his judgment as an argument, he doesn't deal with it. But we say that if the estoppel is successful as far as the TPC is concerned, it should be successful as far as the NAC is concerned, in which case this issue goes away. So, my lord, that brings me to injustice, or unconscionability. Now, in this particular case, what the judge held, it would be unjust or unconscionable to allow the assured to depart from the assumption created by the representation because of the inducement, because the underwriters in question had relied upon the representation which was made. Now, there's a reference in by the Court of Appeal, by Mr. Mr. Justice Robert Goff, in Amalgamated Investment, similarly in another decision called Mears and Shoreline, and again by Lord Burroughs and Tinkler, which emphasizes the importance of such a detrimental reliance creating this requirement of unconscionability or injustice. And the reason it's unjust in this case is not like, for example, the case where there was only a small debt which was at stake. It's important here because if you accept the judge's reasoning up until now, there's been a misrepresentation which has led these two underwriters to enter into this contract on the assumption that the contract did not include the TPC. By signing the contract, but for the estoppel, they would be bound by the contract with the TPC in it, which would expose them to a very large loss. So this is, I would think, a very clear case of unconscionability or injustice, in the sense of it would be unconscionable to allow the broker or the insured to depart from the assumption created by their own representation. This is not small beer. But my lord also, my learned friend also relies upon the fact that this offends the principle in Graukob, the notion that any person signing up to a contract should be taken to have read it. But what I would say, what is clear from Graukob, which is actually not in the bundle of authorities, I'm afraid, but I'll take you to another authority, is that that principle, firstly, probably applies to the extent of incorporation of terms, or at least the contents of the contract. But secondly, there's an exception in the case of misrepresentation. And if I could take you to a decision which is in the bundle, I hope, which is Higgins, which is at tab 14 of the authorities bundle.
It's the instruction authorities, not the estoppel authorities that contain Higgins.
Thank you very much. I'm sorry, it's the TPC authorities, not the estoppel authorities. It's tab 14.
Higgins and Evans.
That's correct, my lord. And I'm looking at page 233, paragraph 75. Now this is well, I said this is a decision of Mr. Justice Saney, but is it quoting a decision of Mr. Andrew Popperwell, QC, as he was. And in paragraph 75, the judge says, the master was regrettably deprived of the benefit of any authority or argument at this point. In particular, she was deprived of reference to the well-established principle that a party who signs a document, knowing that its intent to have legal effect, will generally be treated as being bound by its terms, and will be taken to have read them and be on notice of them, at least absent the case being an extreme one, where there is cogent evidence of the signature being obtained under pressure or by some other proper conduct. I refer in this regard to Lestrange against Graucob and some other authorities. I respectfully adopt Mr. Popwell QC's summary of the case in Du Bois at paragraphs 91 to 92, where sitting as a deputy judge, he observed in relation to interphoto, I agree with counsel for the defendant that such principles have no application to clause 21.2 in the present case. He rightly points out that it remains an undecided question whether the interphoto principle never applies to a signed contract. In that case, the defendant was held not to be bound by a term in a printed set of conditions, which had been provided to him in the form of a delivery note, which he had neither signed nor read. In Ocean Chemical against Exnor Craggs, Evans LJ was prepared to assume that the principle might apply to onerous and unusual clauses in a signed contract in an extreme case, where a signature was obtained under pressure of time or other circumstances. In AHIH against New Hampshire, Lord Justice Ricks doubted whether the principle was properly applicable outside the context of incorporation by notice. In Amiri against BAE Systems, Lord Justice Mance noted the doubts of Lord Justice Ricks and stated that it was unnecessary to decide whether the principle could ever apply to signed contracts. He envisaged that it might do so where, for example, a car owner was asked to sign a ticket on entering a car park for a holiday, maker asked to sign a long, small print document when hiring a car, which in either case proved to be a provision of extraneous or wholly unusual nature. That such cases might be one where the application of the provision was precluded by an implied representation as to the nature of the document. He reiterated the normal rule that in the absence of any misrepresentation, the signature of the contractual document must operate as an incorporation and an acceptance of all its terms. This is a reflection of the well-known principle whose existence and importance was recently emphasized by Lord Justice Morbid in PK against ANZ. So what is, and I'm not going to read the rest, my lord and my lady, but the reason that's important is that the Graucob principle is important. But once you've got a misrepresentation, it ceases to be of relevance. And in this case, it's exactly where we are. We've got a misrepresentation which has been made by the broker to the insurers in question. And whilst one can say, well, they signed the contract and therefore they should be taken to agree to it, that principle, even if it's of application, doesn't apply when there's a misrepresentation.
Even when you've got a clause that says misrepresentation.
Well, I'm assuming that, of course, if I'm wrong about the NAC,
of course, you have to win everything, Mr.
Yeah, I don't think I've shied away from that. I'm not trying to bamboozle the court by saying one of these will
It's just
do.
that as one goes through this excellent, if I may say so, path, one realizes that some of the parts of the flow chart are connected.
They are. No, I quite accept, my lord. If I lose on the NAC, then
And you lose.
I lose.
Yeah.
But so obviously my submission at the moment in relation to Graucob is on the basis that the NAC is not applicable, which I submit still is.
No,
yeah.
I'm not doubting your
Perseverance.
clarity. Good.
So so that's that, my lord. I'm sorry, I'm taking up too much of everyone's time, but and I've already made the point about affirmation not being relevant. And as far as justice is concerned, the fact that it's not a fraudulent misrepresentation, I don't think is a relevant consideration. It's what one has to look at is the impact on the insurers who have relied upon the representation. So that leaves me with my respondent's notice, which is the estoppel by representation.
You haven't really got anything left in your respondent's notice, have you? Because your
You've covered the
whole
point.
case is based on the representation.
Correct. So, but this, in one sense, the respondent's notice is simpler because I don't have to worry about sharing of assumptions or cross purposes or acquiescence or knowledge. the estoppel very simply is created by a representation. It doesn't have to be true, or, sorry, it doesn't have to be known to be untrue, or it doesn't have to, the representor doesn't need to know what the effect of the representation is. And in our skeleton, we've put references to Phipson which list the requirements of an estoppel by representation. So it's, in one sense, the much neater solution. Now, what still remains, of course, is the NAC issue, as far as the estoppel by representation is concerned. And I repeat my submissions from before. And also, I think we may have said in our early skeleton that detrimental reliance is all that you need. But I accept that there is ultimately a question of unconscionability or injustice, or like conscionability and justice, which can play a part. But I've made my submissions about that already. I also repeat that this representation is unambiguous and clear, and the judge understood it as such. So for those reasons, my Lord, just one moment. For those reasons, I would ask the court to dismiss Edis' appeal in relation to estoppel, either on the grounds of estoppel by convention, or estoppel by representation, or, dare I ask, both. Unless there's anything further.
Thank you very much. Even if the representation was ambiguous, your submissions were not.
Well, that's very kind, my Lord.
Yes, we see.
I made many of the points that I might have made in reply this morning, because I apprehended that it might take my learned friend a little time to explain with the requisite clarity some of the points that he wanted to make. And that's particularly true in relation to the respondent's notice and ground 3. And I'm not going to repeat the points that I made there because they'll be there on the transcript. And my Lord, you slowed me down to be able to note them. So I don't think I'm going to need to take the court's indulgence to sit a little longer, but I do have a few things to say by way of reply. The first of them is to take an overview and step back and say we are looking at a case about estoppel. We are looking at a case about the court's equitable jurisdiction, and we do need to have an air of reality about the fact that the judge has found that a broker statement that is made by many brokers every day at the box in the course of broking renewals of insurance contracts for hundreds of millions, if not billions of pounds, somehow precludes an insured from relying on the terms of what is, by the standards of the market, not a particularly lengthy slip.
Have there been lots of comments in the trade press?
Not many, no, on that particular aspect.
They didn't perhaps read the 1,028 paragraphs
Well,
as clearly as we did.
I noticed that it was reported for the first time the other day in one of the Lloyd's reports, and I looked with great excitement to see they said it was too long to report most of the judgment, even in one of the, I think, the Lloyd's insurance and reinsurance.
Don't tell me they left out paragraph 620.38.
Quite possibly, yes. But there it is. It would be an odd situation indeed if it were so simple for a court to decide not to enforce the terms of a carefully negotiated contract with here, in January 2016, the main negotiation, as the judge has found, went on with the contract leader, Mr. Beattie of RSA, who subscribed 25% of the risk and said line to stand. Many of the followers said that that was a very influential matter to them because he was the best known of cargo underwriters. And yet for all such followers to be able to say, oh, but I was told it was as expiring and I wasn't told that actually this particular clause here had a different effect. And I
mean,
therefore,
all your forensic arguments, if I may say so, are attractive. And obviously you understood that we weighed in with those at the beginning. But if Mr. Eggers is right on his legal points, then he's right. And so we do have to grapple.
Well, I'm about to move on to those.
The consequences may be dreadful, but if he were right, well, put it this way: you have to tell us, as I think you are going to move on to do so, precisely why you say he's wrong.
I do, and
one thing you might help me with, please, is I'm still working out why you need an estoppel by convention at all, because the proposition seems to boil down to, if you make a statement which turns out to be untrue, even though you don't understand it to be conveying a particular meaning to the person you're representing it to, that's enough for an estoppel by convention.
Well, absolutely, and I was just about to move on to that stepping stone, and in particular to my lady's case, question to my old friend, Mr. MacDonald Eggers, when he said, I think it was pages 68 to 69 of this morning's transcript, the bedrock of my submissions is, and then stated just that proposition. And my lady said, well, where's the authority for that? And he said, so far as I'm aware, this case will be it. That has not been held in any prior case. And
I was looking
So
at
what has not been held? Can you just understand what you're saying?
The making of where there is an estoppel by convention, by acquiescence based on a representation, knowledge does not have to be established.
Okay.
All you need is the representation to show the acquiescence.
Absolutely, and it was developed this afternoon to say, well, that's because the representation objectively understood, therefore carries with it
An intention
any
that it should be
requirement
acted
or an
upon.
intention, and so forth. And in my submission, there is simply no basis for that contention in any of the authorities that we looked at, and it's a very surprising contention in relation to a doctrine which is an equitable doctrine, and which, as my lady and my Lord the Master of the Rolls have observed, while not precisely a mirror image of, is certainly analogous to rectification for unilateral or
But all that's very interesting. But the fact is, the judge held there was a misrepresentation.
He did, and he held
So
that.
that the misrepresentation was made by the brokers.
Yes.
Right. So, in a sense, that forecloses that argument to an extent, and you move, if you're looking at estoppel by representation, which Mr. Eggers says is his more simple case, you move to decide whether it was relied upon, which it was.
Well, that's his respondent's notice, because of course the judge didn't consider it
No,
as an
I
estoppel
know.
by representation case. He didn't look at detrimental reliance.
I know, but we're here as the Court of Appeal.
But one
And
has
so
to
what this case, just let me finish, what it comes down to me, very likely, is the applicability, is unconscionability at the end of the day, for all the reasons that we exchanged yesterday, and the NAC.
I would agree with that. And although we put our case on 3 grounds in the grounds of appeal, it's always seemed to us that the most simple and obvious ground is the NAC, which the judge found to be applicable, to be validly incorporated, and to preclude an avoidance on the basis of the very same representation, which is now being relied on.
If you're right about that, you're right.
And absolutely. And my learned friend referred this afternoon in that context to the sort of cases that say, well, if you're going to exclude a contractual right, you have to have very clear language. And we know, of course, that this was part of the endorsement that was drafted by Norton Rose in 2015, long after cases such as HIH and all of the others. And if one looks at the NAC, it's simple, but it's comprehensive. It says you shall not reject a claim based on any representation. So there's no basis for saying it doesn't apply to a representation made by the broker as opposed to the insured.
Yeah.
And there's no basis for saying, oh, well, it only applies to remedies for breach of the utmost duty of good faith or avoidance, because the language is absolutely clear and unequivocal.
And then the second point you make is that unconscionability, it does include the rule of Graukob, whatever limitations it may have.
And we discussed
according to Mr. Justice, or Mr. Andrew Popplewell, Queen's Counsel, as he then was, and Mr. Justice Saney, the fact of the matter is that it can be taken into account in unconscionability.
My lord, yes. And when I briefly adverted to the point yesterday about Mr. Poppenwell QC, as he then was, judgment and the reference to Lord Mance and the saying that Browcom won't apply in the case of misrepresentation, my lord responded immediately saying, well, no, an actionable representation, one that bites. And plainly that must be the case, because one can't simply get rid of Browcom because you tell somebody that the sun rose at 8:30 rather than 8:45. So it does continue to apply in my submission. Now, affirmation is not at the forefront of my submissions because the NAC is there, it's clear.
Well, you did brilliantly
So forth.
yesterday, because you gave me or this morning, you gave me the clear idea that you weren't, that we were on a hair, and Mr. Eggers has explained why we probably are, and affirmation doesn't seem to be the strongest point.
There isn't, but there's one point I want to respond to, because
Right.
I think I don't want it to be recorded as necessarily the rule. My learned friend has submitted several times to the court today that it is the law that in the context of insurance contracts, damages for innocent misrepresentation are available under Section 2, subsection 2 of the Misrepresentation Act
Yes.
of 1967. And that is indeed the opinion expressed in the book that Mr. Justice Picken and my learned friend Mr. MacDonald Eggers have written together, called Good Faith and Insurance Contracts. However, back in a case called Highlands and Continental, Mr. Justice Thornton said that he didn't think that there was room for the operation of Section 2, subsection 2, at any rate in the context of reinsurance contracts. And in the case of HIA St. Chase in the Court of Appeal in 2001, 2 Lloyd's Reports 483, Lord Justice Ricks referred to that at paragraphs 51 and 50 to 51 and 116, and raised the issue that there was an argument, as he said at 51, the question then arises as to what role these new remedies, even in 2001, he was describing the 96-16-7 Act remedies as new ones, question arises as to what role these new remedies play in the context of insurance. Chase reserves the right hereafter to submit that the Misrepresentation Act does not apply to contracts of insurance at all. And he reverted to the same point at paragraph 116 and said the position under the Misrepresentation Act must be considered. So I'm not saying my learned friend's wrong, I'm saying he's not necessarily right, and the position has been reserved in this court for consideration on another day by a higher court. So one can't say glibly necessarily that it's the case that damages will always be available under the Misrepresentation Act, because we haven't had cases in which they've been granted.
I think the number of times that damages have been awarded under Section 2.2
Can probably be counted on the fingers of
I
one
think
hand.
less.
I just want to make one point, so I don't have to make it later. That ignores Section 2.1,
Well, Section 2.1's about negligent misrepresentation,
but it's still a non-fraudulent misrepresentation.
introducing a fiction of fraud. Yes, okay.
Absolutely, but no one's suggesting here that there was a claim for damages under either section. So,
No suggestion that there was negligence either.
So that was principal submission. Then I had some more minor submissions to make, one of which in relation to my learned friend's submission that it was absolutely clear that the assumption or representation was as expiring apart from what I've discussed with you. Simply for your lordship's notes, it was said that that was true of Mr. Cook as well as Mr. Blewett. Mr. Cook in his witness statement sets out precisely what his notes said. They are laconic in the extreme. All he notes is the brokerage and the increased limit. There's no reference whatsoever to the other changes that were made to the fraudulent documents cover.
Was it Mr. Blewett who was the assiduous underwriter?
Well, Mr. Blewett's colleague, who got back to him, his peer-reviewing colleague, was the assiduous man who said this is rather hairy. And that was going to be my next reply point, because my lord asked, well, that peer review at Ark, that was after it was all over, wasn't it? And my learned friend said that it was. which is true to an extent. The actual dates are all set out in the appendix to our skeleton argument. The peer review actually took place on the 29th of January.
Right.
So that was after Mr. Blewett had put down his line,
Yes, but it
before
wasn't bound.
or at the same time as all the shenanigans about let's move the TBC about and change.
It wasn't bound till the 31st.
Well, he was bound when he put down his line unless and until the policy was replaced on the 1st with the one that had the changes in it that had been agreed by Mr. Beattie and then approved by Mr. Beattie's colleague. With
Yeah, I tried not to get into all that.
So we don't need to get into it, but it's the fact is on the 2nd they then tried to raise all the queries about hairy matters and so forth. So it didn't stop them from raising questions, and the peer review was not long after the event. It was before the TPC actually got to be in two places. My learned friend made a reference to the fact that this is a contract of the duty of utmost good faith, and that once representation is made, there's a continuing duty to correct it. And I simply remind your lordships and my lady that Edge kept on providing copies of policy wording that had the TPC in it, without on those occasions saying anything one way or the other. My learned friend will no doubt say, well, that's not a correction. But on the other hand, it isn't necessarily a statement that you don't need to read any of this that I keep sending you. Then,
Not once a broker has made now what might become a time-honoured representation that it's as expiring. They need to
What
read
happens
anything ever
when-
again.
but what happens when people then get sent further copies of the policy being told there's changes here? Well, we'll get into an argument about, oh, well, those weren't material changes, but plainly that can't be a continuing representation as expiry if Mr. Lockyer's sent round another version of the document on the 1st of February. My learned friend skated very quickly over his respondent's notice point that this court should find that the Estoppel worked for the NAC just as much as the TPC. But of course the judge specifically limited his findings on inducement to the TPC, despite having been asked in the closing submissions to make findings about the NAC. Oh yeah. On the NAC, my learned friend tries to say, well, clause 21C of the NAC doesn't apply because it doesn't mention estoppel, and also because estoppel is a rule of evidence and it's not tantamount to rejecting a claim. We say that's splitting a hair, a triumph of technicality. What matters is the substantive effect on the legal rights that the estoppel has. Here, it has the effect of allowing underwriters to reject a claim on grounds of a non-fraudulent misrepresentation. Moreover, that's how it was put in the defence, because they not only pleaded at paragraph 29 as an estoppel, they pleaded at 57, because of the estoppel, you can't bring your claim for these credit losses. And then, my lord, the Master of the Rolls, told us that Spry referred to the recallings case. That was a case about whether beneficiaries of a trust, the plaintiffs sought to bring a claim against a trustee bank for breach of trust, but they took 4 years to issue a writ. But for most of that time, they didn't actually know what their legal rights were, which enabled them to bring the claim against the bank. The bank raised various defences, including acquiescence, and the Court of Appeal held that the defence of acquiescence failed because there could be no acquiescence unless and until the acquiescing party knew what his rights were. And that knowledge, necessary knowledge, hadn't arisen for 4 years. And so in that case, the passage of time did not amount to or show acquiescence, because during that time the claimants didn't know their rights. And in that context, at page 20 of the report, Lord Justice Upjohn said something which certainly made me smile when I read it, and I did wonder whether perhaps the Master of the Rolls had in fact sneaked a look at it before coming into court this afternoon, because it turns out that the beneficiaries in this case included the hapless George, who was a member of the bar. And what Lord Justice Upjohn said, in this case it would be wrong, we feel, to place any disability on the beneficiaries because it so happened that George was a member of the bar and had been in well-known chambers. He had not been in chancery chambers, where it may be said that these things are better understood. But the real truth of the matter is that a party cannot be held to have acquiesced unless he knew or ought to have known what his rights were. On the facts of this case, we cannot criticise any of the plaintiffs for failing to appreciate their rights until another learned junior, whom they consulted on the far-fetched and futile scheme of George's for avoiding a state duty on his mother's death, advised that the advantages might be improper. And that was the context in which it arose, my lady and my lords.
It was a good dictum, wasn't it? Yes.
Really good.
So, subject to any questions that I may be able to assist with, those are my submissions.
But I was always taught at university that Lord Justice Upjohn was always right. And so there we are. Anything else?
Yeah, there is just one. I'm sorry to harp on about this. It may well be that my lord is entirely right that this will turn on equity, the justice of the case, and the NAC, and what we make of the NAC. But I'm still concerned with this question of whether or not, in order for there to be acquiescence, there has to be knowledge of the mistake. It seems to me that the position is that there doesn't seem to be any clear authority that directly addresses it, other than even Mr. Justice Mann, because there's the concession and because he's not dealing with the particular position of representation. So I'm trying to sort of drill down into the underlying principle, but looking at the way that the judge approached it in paragraph 697, it seemed quite clear to me that the judge is using the word acquiescence in a different sense from the representation, because he says the assumption that everything was as expiry was acquiesced in by Edge and indeed was the result of positive statements. In other words, the acquiescence was brought about in some way.
And he doesn't conflate the fact that a positive statement was made
With
with itself
acquiescence.
being acquiescence.
But
So
what
that's
do,
not
what do you submit acquiescence actually means in this context?
I submit that in this context, as in all the other contexts, including the one that we just looked at in relation to the hapless George, acquiescence does indeed require knowledge that the thing you're acquiescing in, the other party's mistake, you've got to know they're making a mistake. And there is no rational reason of principle, certainly no prior authority or precedent, which should cause or drive you to construe acquiescence in the context of an estoppel by convention based on a representation as saying one does not have to have knowledge and it is purely to be determined objectively. And when I was agreeing with my Lord the Master of the Rolls that the NAC was a short way home and that overall the unconscionability and equity aspects of this should point in favour of my client's case, I was not in any way intending to shrink from our primary ground of appeal, which is that you do have to have knowledge that the other party is labouring under a misapprehension or a mistake, and here the judge has found that we did not.
He's made no finding that you did, to be accurate.
Yes, that's true, and I'm not going to get into Monday's correspondence, but we did have a bit of a debate about upon whom was the burden of proof to explore knowledge, and the fact that we said it was explored at trial, but there's no finding. My lady, I don't know if that
No, thank you, that's helpful.
answers the question.
Thank you.
Thank you very much.
Well, that concludes the appeal hearing. Mr. Eggers, you're not getting up in order to make
No,
further submissions.
just out of respect for the court.
Thank you. So we'll take time, it may surprise you to hear, to write our judgments, and we'll hand them down in the usual way. And when we do, will you please provide us with typographical corrections, but not re-argue the case. and agree any consequential orders. If you can't agree them, then we will deal with them all in writing. But may I, on behalf of the court, thank counsel, leading and junior, and also solicitors and public clients who have at least presented us with such an interesting set of circumstances for us to consider. Thank you very much.
Thank you, and we're all grateful to the court for giving us time to explore such an interesting series of philosophical and legal propositions.